So in Washington, if you don't have a will, you die intestate, Latin for meaning without a will. The laws of intestacy are RCW 11.04.015. I'm just going to share my screen really quick. That is the statute on descent and distribution of real and personal property. If you want to take a look at it, try to figure it out, feel free to do so. I'm going to be sharing with you how it impacts you. Let's start with the simplest situation possible, and that is you are a single person. If you are a single person, what that statute says is where your assets go when you die if you haven't indicated where they go. So how does the whole process work? Well, there's going to be a probate because you haven't given direction to your assets and you haven't set up a revocable living trust, or you don't have a will. If you have a will, there'll be a probate, but the probate is way easier when you do have a will because you will have named, excuse me, who the executor is, who gets what. But you haven't done that. So we are dealing with Washington State's laws of intestacy. And what that means is who gets what. Now, if you're a single person, your kids are going to inherit from you. That is what the state thinks you would want to have happen. And oftentimes that is actually the situation that you would want. So I'm going to share this little graph I have here, which is intestate succession. So if you're not married, the answer is no. You have descendants. Yes, 100% of your estate goes to your descendants. And what do I mean by descendants? That's your kids. What if one of your kids has passed? Let's say you have two kids and they're both alive. They will both inherit equally from you through the probate. And likely is in the probate process, one of them will have been appointed what we call personal representative. It's also known as as actually an administrator of your estate. When there's a will, it's called executor. When there's not a will, it's called administrator. That's just technical stuff. But so your two kids inherit equally. Okay, that's maybe what you wanted. And if one of your children doesn't survive to inherit, then their children, the deceased children, inherit that 50% share. And that might be exactly what you would have wanted. What if you don't have any kids? Then the state says, well, are your parents alive? And if your parents are alive, then your parents inherit. What if the situation is this, that in your family, you have been raised by your stepfather. You don't have a will. Mom and dad are alive, and mom is married to stepdad, and he's the person who perhaps you consider to be your father. Though you still, have your biological father, and you die. Where do your assets go? And you have no kids. Well, they are going to go to your biological mom and your biological father. I need to add another fact to that stepdad never adopted you. So then it goes to these two people. Is that what you want? Maybe, maybe not. But that's what the laws of intestacy say will happen. Obviously, if you want a different result, see an estate planning lawyer and get a will in place to give you the result you want. Let's continue with the single person situation. Let's say you don't have kids and your mom or dad, if there's one of them that survives, they get it all. But let's say mom and dad are both gone. Now where do your assets go? Well, under the statute, it says, do your parents have any living descendants? Well, what does that mean? Really, we're talking about the siblings, your siblings, full siblings, half siblings. As long as there hasn't been an adoption, they're legally in play here. So your siblings would inherit from you. And if a sibling didn't survive, then in their place, the child of the sibling that you have would inherit their share. So all this is probably making some sense, that what the laws of intestacy look to do is distribute your property, and we're talking about a single person here, according to who is closest to you in bloodlines. Really looks at bloodlines. So if you don't have any siblings alive, then it goes to nieces and nephews. If they're not alive, then we're saying, well, who are your cousins? And if you have cousins or any deceased children of cousins, whatever degree that is, they inherit from you. So that's pretty much how far we go. And then at that point, let's say that you don't have any cousins or, issue of cousins, etc. Then what happens? Well, if you don't have anybody that close to you in bloodlines, does it go to the state? Not quite yet. If you have a stepchild from a deceased spouse, then your stepchild will inherit from you. And then after that, it goes to the state of Washington. So it is intended to go to the people who, from a bloodline perspective, are closest to you. And after you've exhausted all of these bloodlines, you don't even have cousins or anybody who's still alive that survives you, then it will go to your stepchild, and then it'll go to the state. So that's a single person situation. Now keep in mind that there is no control over where your assets go. You haven't indicated who's going to be administering your estate, who's going to be the personal representative, and you haven't said that you want a trust for anybody. Maybe one of your children is disabled and they get government needs-based benefits. So they inherit from you. They will lose their benefits until they're spent down. Or let's say you have a child that you didn't want to inherit from you. So they are going to inherit equally with the other children. So I think you get my drift. What I'm saying is you have given up all control over where your assets go to the state's laws of intestacy. That is what happens with a single person situation. In a way, a single person passing with no will is actually easier in a way, and then also more difficult in a way than when one of the two spouses passes.